All right, so today we are going to be continuing on looking at our legal rights under Canada's Charter of Rights and Freedoms section. We've looked at section 7 and 8, and so we are continuing on with section 9. So if you look at your charter, section 9 says that everyone has the right to not be arbitrarily detained or imprisoned. Okay, the concept of being detained means being held by police, and imprisoned, of course, means after you have been sentenced and found guilty for a more extended period of time. And arbitrarily means for no reason. Okay, so in more layman's terms, people cannot be held for questioning, arrested, or kept in jail by police without a good reason and without sharing that with you. And arbitrary means random. Okay, so for section 9, we do have a law in Canada that does violate this section of our charter that has been challenged all the way up to the Supreme Court of Canada and was found to be a reasonable limit using section 1, and so the law remains, and that is the RIDE program. So if you're not familiar with that, what it is that the police will actually block off a chunk of a road, usually late in the evening, and every single person that wants to go through, wants to drive on that road, must stop and answer, I believe it's 2 questions from the police about alcohol and drug use consumption. So usually you're asked if you've consumed any alcohol or recreational drugs in that evening. The majority of people, once you roll down your window and answer, honestly, the answer can be yes. If it's, I've had one drink 3 hours ago, and I'm of age that's part of the license that I have that I'm allowed to have done. But what it does is it allows the police to have an opportunity. They usually have their face fairly close up to you to be able to smell your breath and see into the vehicle. Again, most people are then let to go on their way. Some people are pulled over and they are asked to do a breathalyzer. Okay. The main argument for why this was allowed when the section 1 violation was being looked at, because it is an arbitrary detention. You are being stopped randomly. Okay, based on what road you are driving on. The main argument is that there is huge statistics that show how much of a reduction in drinking and driving and drug use and driving there is when these programs are in effect. So generally they are running on significant evenings. There's definitely usually one always in KW or a few on New Year's Eve, during Oktoberfest, during other situations. If there's ever, so for example, during the Olympics when the Canadian hockey teams were up for gold, big significant events where large parties would be being held, this is something that is often done. And so just the threat of it happening has been shown, and then the actual stopping people and getting them off the road has been shown to significantly reduce the number of incidents and deaths that have to do with intoxicated driving. And so that was how it was justified. So again, we do have this law that still exists that definitely violates section 9. But it has been justified. Otherwise, if, for example, you were driving and you were pulled over by a police officer, they have to have a reason for pulling you over. They have to have seen you doing something that was against the law. They cannot just be doing it randomly, or else it would be a violation of this right. Continuing on, section 10 gives us our rights while we are under arrest or detention. Again, detention would be when you are first being held or questioned, and arrest is once you are fully under arrest. Okay, if you were to read through it, there is an A, B, and a C section to this. Okay, but what it basically breaks down to is that you have a right to be told why you are being arrested while you are being arrested. They cannot delay and not tell you why. So yes, you have the right to be told that you may get the assistance of a lawyer, and in Canada, legal counsel is available for free for the accused. So you may have seen on TV when people are being arrested, you see the officer saying, you have the right to remain silent, you have the right to speak to a lawyer. Our verbiage that we use is different here in Canada and then what is on TV, but this right does remain the same, and it's specifically that it must be told to every person. So as you are being detained or arrested, you need to be being told why, and you need to be being told that for the fact that you are eligible for a lawyer, whether you can afford it or not. Section C, which I haven't put on here, if you do read it on here, it says to have the validity of detention determined by way of habeas corpus and to be released of the detention is not lawful. So again, we're going back to this concept of habeas corpus. You have to be arrested for a reason, and there needs to be proof for it. Okay, so this kind of links to the last one with the arbitrary. So not only do they need to have some sort of proof with habeas corpus, but you also have the right to, ask that it be reevaluated, and that's part of our criminal process, and you would be released at any point if there is not enough evidence against you. Okay, I have an article here that you can explore in your own time, but it's a situation where these rights were violated. So again, these are the rights of the accused and often the criminal in the case, and it is important to our society that they are upheld, although it often, when we see it in the news, seems to be in the reverse. Okay, so there was a man who I believe was driving drunk, and he ended up killing a young girl. Okay. When he was in the accident, he was taken to the hospital. Okay. And while in the hospital, he was under arrest. He was handcuffed. And before the police officers told him that he had the right to a lawyer, they took blood from him, and that blood was tested to prove that he was intoxicated at the time of the incident. Okay. However, that violates our rights when under arrest. When we are put under arrest, we must be told why we are being arrested and that we have the right to a lawyer, and that lawyer would help explain to us the additional procedures and what you can say yes to and what you can say no to. Because this person was not given access to a lawyer within a certain the needed amount of time, and other things were done, that evidence that had been collected was thrown out, and so they had no proof that this person was intoxicated at the time of the incident. And so because of that, the type of sentence that they could charge him with was different, and the sentence was different. And so the person only ended up getting a 3-year prison sentence for it, even though, as the father of the little girl is saying, everyone knows they were drunk, okay? But the evidence that was needed to be able to put that into courts was deemed to be not allowed because his rights had been violated. Okay, so very, very important that police officers do follow that procedural law, which ensures that all citizens' rights are maintained and that any evidence collected can be used in trial. Okay, and Section 11 is talking about your rights when charged with a criminal offense. Okay, these are again written here. There is A, B, C, D, E, F, G, H, I. Okay, there's lots of them. Okay, the most important ones that you probably heard before: to be assumed innocent until proven guilty. Okay, that is going to be there. To be tried in a court within a reasonable amount of time. Okay, and we're going to be looking at a case about that. You also cannot be forced to testify at your own trial. So when we look at criminal trials, we're going to see instances of this, but when the Crown, when the government is putting their case forward, they cannot actually call the accused to the stand. The person that's being charged gets to choose whether they go to the stand or not as part of their own defense. Okay. And you have a right to a trial by a jury for certain serious charges. If you don't want it to just be a judge, you do have a right to a jury of your peers. Okay, so there's a few other technical ones in there, including not to be denied a reasonable bail without just cause. We're going to be looking at that concept of bail when we get to criminal law. Again, to be informed without unreasonable delays of the specifics of the offense. Okay. Again, you have that right when you're being arrested, but you also have that right when you are being charged. So two separate incidences, that those might be different. Okay. And then a few other ones in there as well. Okay. But these are the kind of the main ones that we are going to be looking at that are really important that people understand. Okay. One of the ones that's hit the news most recently has been the concept of being tried in a reasonable amount of time. This was a case of Jordan. So this was a person who had been arrested and was waiting in jail to go to trial. So even though we have the concept of innocent until proven guilty for severe charges, okay, we do hold the accused in prison. It's not the same prison that people that have been charged and found guilty are in, but it is a very similar environment. And so even though in theory you are innocent until proven guilty, you're still sitting in a jail cell, unable to go about your life while you wait around for your trial. In Canada, our average time to go to trial, especially for a jury for serious offenses at the time, was around 3 to 5 years. So that was before you even got to have your trial to determine if you are guilty or not. Okay, and so this person decided to take this to the Supreme Court of Canada, okay, because of the delays in the trial and the results thereof, okay. And here's some of the responses to it, okay. It says that the survivor, the victim in this case, has, is very, very upset because somebody's case was thrown out, was not tried, so they were found innocent and let go, because it was held for too long. Okay, it says in the 2016 Supreme Court ruling known as the Jordan decision, this set out timelines for courts to hear cases. Okay, it is estimated that hundreds of cases have been thrown out since that decision came down. Okay, and that's unfortunately the reality of what happened as a result of this decision. Okay, so here is the case itself. So in 2016, the Supreme Court of Canada rejected the traditional framework used to determine whether an accused was tried within a reasonable amount of time. So they basically took the precedent that had been set in the past and threw it out and replaced it with a presumptive ceiling of 18 months between the charges and the trial in a provincial court, okay, or 30 months in other cases. So 18 months is a year and a half, 30 months is 2.5 years. Okay. And what happened when they made this decision is that in no way did we all of a sudden have more courts. In no way did we have more judges. In no way did we have any more capacity to have cases. Generally, cases are not delayed from happening for any reason other than waiting for a time slot in the calendar for that case to actually happen. And so when we were running between 3 and 5 years, and then all of a sudden they're saying it has to be 1.5 or 2.5 years that it happens, there's going to be this whole backlog of cases that are either already over that time limit or right at that time limit and can't get space to actually be tried. And so there was actually hundreds of people who were, either home on bail or sitting in jail cells waiting trial for fairly significant charges who were sent home, who, they just were kind of unarrested. They're not found not guilty because they never had a trial. They just were let go for that case and no trial is ever going to happen for that. Okay. And this was definitely a really interesting public situation because it is looking at the rights of people who are sitting in jail. And we definitely, don't want innocent people who would go to trial and be found to be not guilty to have sat there for 5 years. But at the same time, we looked at victims in society who have been harmed in cases where it is believed that they're going to be found guilty and they're just allowed to walk free. And so it's definitely, there's a few articles there that you can read on the back and forth of this, of how society wasn't necessarily understanding this. And you may have your own opinions on whether this is fair or not or equitable given balancing those rights based on those conversations we've had before of, are criminals granted the same rights as the rest of Canada? All right. Section 12 of our legal rights has to do with cruel and unusual treatment or punishment. Okay, it reads, everyone has a right to not be subjected to any cruel or unusual treatment or punishment. Again, remembering the Charter is always talking about by the government. Okay, and so specifically we are looking at situations saying the government cannot treat or punish individuals in a way that is unnecessarily harsh. Okay, when deciding if something is considered cruel or harsh, what the courts consider is the gravity of the offense, the personal characteristics of the offender, the particular circumstances of the case. Okay, so there is not a clear-cut example of what is considered to be cruel and unusual, but we have seen a few situations come up recently, specifically around solitary confinement. You can use these links to explore them, and prisoners stating that they are being treated in a cruel and unusual way by being put into solitary confinement. Yes, there are laws and rules in place around who should be put there, but again, they're somewhat up to the prison guards at that time. And there was actually a judge ruling on this one, which limited the amount of time that somebody could be put into solitary confinement after cases came forward that showed that people had been put into it for months and months on end, which is deemed by psychologists to be incredibly cruel and unusual punishment. Okay, this is one that is consistent not just to people that have been arrested and detained, but to everybody. So this would also include interrogations that police officers are doing. Okay, they cannot, when questioning somebody, they cannot be doing anything that is deemed to be cruel and unusual in those situations either. Okay, and then finally, sections 13 and 14 have to do with the rights of the witnesses in a court case. Okay, so 13 talks about how a witness who testifies in any proceedings has the right not to have any incriminating evidence so given held against them. Okay, and number 14 says a party or witness in any proceeding who does not understand or speak the language has a right to an interpreter. Okay, so two different things here, but they do both have to do with witnesses. If you are asked to be a witness in court, okay, we want witnesses to speak the truth, and so they have extra rights in that role as a witness. One of them is that anything that they say while they are a witness cannot be used against them. Okay, so if, for example, somebody is being charged with selling an illegal drug, if we have a witness come to the stand and say that, yes, we know that they give very important evidence saying, yes, I know that they sell drugs because they sold them to me and I bought them from them. Okay, that's important evidence that needs to be in this case, but nobody's going to give that if the second they step down from the stand, a police officer is going to arrest them and say, you just admitted that you bought illegal drugs, therefore you're under arrest. Okay, so what is said cannot be used as evidence against them. Okay, that doesn't mean that the police won't have their antennas up and try to look for other evidence about that person, but it means that those specific words said in that court case are protected and cannot be used as that evidence. And then on the other side, interpreters. So if you're hearing impaired or you don't speak the language, they will provide an interpreter for you to be able to be a witness in a court case. All right, so those are our legal rights. As I mentioned, it is a very, very large section. You've already done a quiz on both sections 7 and 8. So your final quiz for this will be on sections 9 through 14.